He apparently didn't catch.
Testing, testing. Commissioner O'Donnell, can you hear us?
Oh, okay.
Commissioner O'Donnell, we couldn't see you earlier. Are you good? Can you hear us?
Oh,
Yeah, we can hear you.
oh, you can't hear me.
We can hear you.
Oh, you can hear me. No one answered me. I've been trying for 5 to 10 minutes.
Okay.
Okay, welcome to the Public Service Commission's administrative meeting for September 27th, 2023. And we have minutes from the last meeting. Take a motion to approve the minutes.
I'll second that.
Commissioner Suchman,
Aye.
Commissioner Barbe,
Aye.
Commissioner Richard.
Aye.
I vote aye. Oh, Commissioner O'Donnell.
Aye.
Okay, and I vote aye. So with that, Mr. Executive Secretary.
Good morning, Mr. Chair. There are two items on today's consent agenda. Item number one is a notice of name change from Direct Energy Business Marketing LLC, and item number two consists of revised tariff pages from Baltimore Gas and Electric Company.
Okay, I move that we, on item number one, I move that we note the filing. Commissioner Suchman,
Aye.
Commissioner Barbe,
Aye.
Commissioner Richard,
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. On item two, I move that we accept the tariff provisions for filing with an effective date of October 1st, 2023. Commissioner Suchman,
Aye.
Commissioner Barbe,
Aye.
Commissioner Richard,
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number three on the administrative agenda is a request for approval of an electric meter from Baltimore Gas and Electric Company.
Morning, Mr. Chair, Commissioners, Michael Spiegelman on behalf of staff. This item concerns a request by Baltimore Gas and Electric filed on July 14, 2023 for approval of an E650 S4X model solid-state electric meter manufactured by Landis+ Gyr.
Mr. Chairman, I can't hear the presenter.
Okay. And why don't you speak a little louder? So.
Manufactured by Landis+ Gyr for electric commercial submetering application. Public Utility Article Section 7-301A requires a person to gain Commission authorization before use of a gas or electric meter, and PUA Section 7-303D4I and at 2 states that all submeter equipment is subject to any regulations and standards adopted by the Commission for accuracy testing and record keeping of gas or electric company meters. Commer 2025-0104A further requires that 1. All submitters installed in compliance with these regulations be of a type and class to properly and accurately register electrical consumption. 2. The meter type and design shall meet the applicable provisions for the latest edition of American National Standard for Electric Meters, Code for Electric Metering, the NZC 12 standards. And 3. That any submitter installed for billing purposes be approved by the Commission. In present filing, BGE has provided documentation that this meter has been tested and confirmed to all applicable NZC 12 standards for electric meters as required by COMER. In addition, E650 S4X is already approved by New York Public Service Commission and Measurement Canada. Therefore, staff recommends that the Commission approve BGE's request to approve the E650 S4X model solid
Mr.
state.
Chairman, I can't hear the presenter again.
Okay, just back up a little bit and then try again. And again, speak louder.
Sorry. Therefore, staff recommends that the Commission approve BGE's request to approve the E650 S4X model solid-state energy meter manufactured by Landis Plus Gear for electric commercial submetering application. If approved, staff will update the list of approved devices located on PSC website. Thank you.
Good morning, Chair Hoover and Commissioners. Crystal Barnett
Okay,
on behalf of Baltimore
why-
Gas and Electric.
Yeah, pull it down a little bit.
Thank you.
Okay.
Crystal Barnett on behalf of Baltimore Gas and Electric. With me today is Sean Gorman, our Manager of Engineering, and Chris Hopes, our Section Engineer. They're subject matter experts. We have reviewed staff comments and do not have anything additional to add. We agree with staff's recommendation to grant the approval of the meter. We are available for questions.
So, any questions from anyone? Commissioner O'Donnell, you have any questions or? Okay, with that, I move that we grant Baltimore Gas and Electric's request to approve the E650 S4X model meter, electric meter for use in electric commercial submetering applications. Let's vote. We'll start with Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, items 4, 5, 6, and 7 are revised tariff pages from respectively Delmarva Power and Light Company, Potomac Electric Power Company, Baltimore Gas and Electric Company, and the Potomac Edison Company.
Okay, so why don't we have staff, OPC, and the 4 companies come up to the table here, and we'll kind of deal with this jointly. So why don't staff do the introduction? To the extent you have to differentiate between the 4 applications, that's fine, but don't feel you got to repeat this same overall information for each one. So.
Good morning, Mr. Chair and Commissioners. Eric Delgado on behalf of staff. On September 1st, 2023, the Delmarva Power and Light Company, DPL, the Potomac Electric Power Company, PEPCO, the Baltimore Gas and Electric Company, BGE, and the Potomac Edison Company, PE, filed tariff revisions to their net metering riders to comply with the requirements of Senate Bill 143 and House Bill 1188, which takes effect on October 1st, 2023. Senate Bill 143 is an act concerning the accrual of net access generation and net energy metering for net energy metering and virtual net energy metering. The amendment to the bill permits community solar generating system subscribers and eligible customer generators to accrue net access generation indefinitely. House Bill 1188 appends Public Utilities Articles 7-306 with entities defined as eligible customer generators. Staff and the utilities have worked with members of the net metering work group to obtain agreement on appropriate tariff language to comply with the new law. Staff's understanding is that the utilities and parties participating in the net metering work group do not object to the proposed tariff language. Staff finds that the utilities' proposed tariff language is consistent with the law. However, currently COMAR 2050-1005E1 and 2050-1007B do not reflect the legislative changes. The net metering work group is currently working on revised regulations for the Commission to consider in the future rulemaking. Additionally, for PEPCO and DPL, staff recommends switching one word in the language from the to each to better reflect that customers can change their accrual method once per year. There are no reservations by the net metering work group about staff's proposed edits. Staff recommends that the Commission accept for filing the utilities' proposed tariff revisions as revised by staff with an effective date of October 1st, 2023. Staff also recommends the Commission direct utilities to file clean copies of their tariff and grant waivers of COMAR 2050-1005E1 and 2050-1007B until updated regulations are adopted. Thank you, and I'm available to answer any questions.
Okay, Mr. Offsander.
Good morning, Chairman and Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel. We filed a letter on Monday explaining our position. And to the extent that it wasn't clear, OPC does support staff's recommendations in this case. As staff's bucksheet points out, the effective date of the Net Energy Metering Flexibility Act takes effect this Sunday. So it's important for the utilities to have tariff provisions in place to implement the requirements of that new law. So we do support the Commission's approval of those tariffs. However, we did point out a few concerns that we have that represent unresolved issues. One of those issues is the manner in which customers will use to elect one of the two options that are now available to them. We support the tariff language that each of the utilities has submitted that makes the existing 12-month annual accrual method the default option unless the customer takes affirmative action. We do have some concerns about how customers will get information about the effects of making those elections, and as noted in our comments, it is our understanding that all parties agree that a commission-approved form would be the best path forward to accomplish that, or a form approved by the commission. And it is my understanding that that there were discussions yesterday, and that I think that some utilities are working on a form, and I think some utilities are working on updating their web page to provide information on the two options to customers. We support those efforts. We think that problem trickles down into the other two issues that we pointed out. One of which is that two of the company's tariffs include language that is included in the text of the Net Energy Metering Flexibility Act that says once a customer makes an election to switch from one method to another, they cannot switch back. Well, if they switch from the annual accrual method, they cannot to an indefinite accrual. They cannot switch back unless the company approves the switch. That language is in the statute, and two of the utilities have taken that language and put it in the tariff. So, and we understand that that is similar to other sections of the tariff revisions that take language from the statute. Normally, that is not an issue. However, we do think that without the commission-approved form, or without seeing the messaging that the utilities are sending, there could be confusion caused by that language, because it could be read by someone as saying, once you switch, you cannot switch back unless we say so, and we might not say so. So I think that we are concerned that it is our understanding that the utilities do intend to permit customers to switch back from the indefinite accrual method to the annual accrual method. So I don't actually think that there is a a problem that is going to occur in the future that we fear. However, for reasons of clarity and proper communication to consumers, we would prefer that the utilities criteria or circumstances under which they would approve a switch are spelled out in their tariff. And I think that simply including that language in there actually creates a problem, because it does not communicate clearly what circumstances BGE, under which circumstances BGE and PE would approve the switch. We noted that PEPCO and DPL's tariff provisions don't use that language, and they do set out the circumstances under which the customer can switch back. So we would prefer that sort of language in these provisions. And then the final point that we made was that the statute, in addition to the providing the new options, states that the Commission shall establish a method of valuing the excess generation that a customer has elected to accrue indefinitely. And at that point, at this point, that has not been done. There are provisions in each of the tariffs that do explain how that excess generation will be paid out. However, we think that language existed at a time when there was an annual accrual method, and it essentially averages SOS prices. And under an annual accrual method, the things that we're concerned about aren't problematic. But when you have a situation where a customer could potentially indefinitely bank credits, meaning that they could bank credits for years and years and years, the method that's spelled out in the tariffs concern us, because there could be a situation where the credits that are eventually cashed out, if the customer switches back or closes the account, end up being much higher than the excess generation that would have been paid out had the customer been receiving the payouts under the 12-month annual accrual cycles. So for all of our recommendations, we wanted to raise these issues so the Commission was aware of them, and to perhaps provide direction to the net metering work group to address those concerns, particularly with the way the Commission intends to handle, if it does decide to handle this by approving a form, and then to have the net metering work group fully vet the method by which the utilities will use to value the indefinitely banked credits, and hopefully prevent any problems that could occur down the line for customers that bank credits for a lengthy period of time. I will point out, and I'm sure staff will chime in, that I think what staff is intending to do at this point is to monitor the levels of banked credits, and then perhaps recommend changes based on whether or not customers in reality do end up banking hundreds or thousands of kilowatt hours of excess generation, and then take appropriate steps at that time. We don't think that this is a problem that needs to be addressed in the next 6 months, but we do think that it's a problem that every year that goes by that it's unresolved, I think could create a problem in the future. And in the meantime, without a settled rule for how the excess generation will be calculated, I think there's some uncertainty, and it's better public policy, in our opinion, to have the method by which the credits would be valued decided now, and just have the matter settled.
Okay, so let me ask one question related to this issue about the form. My understanding from reading all this stuff was that there was some work being put forward to create a form, either a form created by this group or a form approved by us, but you kind of ran out of time given the effective date. So my question is, if there was a form, either a Commission-approved form, would it address your first two concerns?
Well, I think that it would, to the extent that it includes language that make it clear to the customer what the effect of the switch will be, and under what circumstances they would be permitted to switch back. And then what we would also like to see in the form is a statement about how the excess generation credits would be valued in the event that the customer switches back to the annual accrual cycle or closes the account. So, I think that the form would be the method by which all of the three problems that OPC raises in its letter could be addressed.
All right, so the next question I have is development of this form. Is this a long-term project or a fairly short-term project? And I guess I would like not only your opinion, but everybody else sitting at the table.
So I think that it would be a short-term project to distill what is currently in the utilities tariffs into a form that would be easily understandable to customers. To the extent that the form would include the statement about how the utility will calculate the value of the credits, that could be a longer-term project depending on how long it takes the net metering work group to come to consensus, or at least to identify the areas of non-consensus and submit that for commission consideration.
And what's staff's thought on how long it might take to develop a form?
Your Honor, if I may,
Sure. Mm-hmm.
I'm Philip Vanderhayden. I'm the staff facilitator for the net metering working group. We talked about putting a form together, and we do not anticipate it would take before the end of this year to sort it out. My understanding is the form would be primarily used to allow a customer to select their accrual method when they apply into the program. And this was the means of making sure that customers would be given that opportunity when they enter the program, either through their interconnection application for a rooftop customer, or when they apply and subscribe to community solar. So we needed a form. The form should have the customer's election indicated on it. The utilities have asked that the customer would have a signature line on that form so they could be assured. One of the additional revisions made was that a third party, and this is in the tariff, could submit the form on their behalf, and that is to sort of allow this to be a little bit more automated so it can be picked up on the way into the program. So we need to have the customer make that signature and identify the account and everything else. So we don't anticipate it's a difficult form to put together. We have similar types of forms that are sort of managed by staff, the application process for community solar, for example. And it has not reached the level of discussion where you have all those elements. We don't anticipate that it would be difficult to put it together. And there is still some consideration of whether or not this will be a common form that the staff will produce, run past the various stakeholders and net metering working groups and the utilities, and then essentially just make that an official commission form that all of the utilities will use, or if the utilities would like to have something specific for themselves. That hasn't been dealt with yet, but so there are some options. But primarily this would be used as a means to allow a third party to capture this information and use it as part of the application process so that all new customers would have that opportunity. There are still other options for customers that are already on net metering. Once the form's developed, they certainly could use that. But each of the utilities is ready as of the effective date of the tariff on October 1 to receive phone calls to be able to record that information. So we're trying to cover all the bases, old customers and new customers. I expect we'll have this put together by the end of the year at the latest.
So is there any profit in deferring action today until this form is developed? I mean, I understand that the effective date of the statute is October 1, so obviously it's not going to get done by then. But does it make sense to defer doing anything today until this form is developed and presented to us, and then doing everything all at once?
I think it would be, I don't see any benefit to waiting till the form is developed. The law will go into effect. Customers may wish to begin recording that election, or at least understand what that is. And I think the various participants, in particular the larger volume of these community solar subscriber organizations and subscription coordinators, they may need to begin to prepare their systems to be able to use a form like this so that they can, and sort of batch process these things as they're signing new customers up. So I think we want to have the tariff in place. The tariff language was deliberately written so that could allow the flexibility to be compliant with the law now and still allow the use of a form once it's developed. I would also mention, I don't know if this got picked up, in that we have asked for waivers of the two portions of COMAR that are not up to date with the law. At the time we make those changes to COMAR, there will be certainly an opportunity to review any additional requirements for the program based on that law, including establishing the method by which the commission will approve the rate of the payouts. So right now, the way the law is written, the payouts are basically the most recent 12-month average, and one could see that if that persisted and customers generated excess generation for a number of years, that might build up, and to use the most recent rate, I think was an issue raised by OPC, like, is that the correct rate to pay out something 10 years hence? So we don't see that as an immediate problem. It may not be a problem for a year or two. However, I would recommend that we use the regulations as a means of sort of nailing that down and making it common for all of the utilities that will need to follow that. And but we still believe it's important to have these tariffs in place so that we're compliant and so that anyone who is planning to have to participate at any portion of this at least has some language that they can begin to base their plans on.
So do you have a question on sort of what we're on right now? Because I do want to give the companies a chance.
I do. Yeah, no, and I appreciate that.
Okay.
It just seems to me that making decisions about whether you're going to sign up for a 12-month accrual or an indefinite accrual requires that you understand what you would be gaining in terms of making one decision over another. And if you haven't nailed down how the indefinite accrual method will work, it's very hard for a customer to make a choice. I guess I'm wondering. I mean, I understand the need to try to get the language in place. I wonder if there's a way to suspend the decision making in terms of going with 12-month versus indefinite until how you determine what whether you're going to sort of spell out how the customer gains recovery or sort of is put off for some period of time. If there's a way to suspend making determinations about which method you go to until the form is done. So, and especially if we're not quite at the end of the year period. And I guess that would be a question for the utilities as well. Getting the language in place, but allowing the customer to easily go from one to the other once you decide on how you're going to allow for recovery for that customer, depending on the choice that they make. Does that make sense to you? I'm just sort of wondering if that is something that could be done, because I do sort of see the value of getting this thing in place, but at the same time, a customer's really not able to make a decision about which method to choose until they have information about which is the most beneficial to them.
Good morning, Commissioners. Joel Michelle on behalf of BG. Just in response to Commissioner Suchman's question, I don't know if this information will help, but the customer's election is not a sort of one and done election. They will have the opportunity to choose a method of accrual once annually for March 1. And so my thought is that if the Commission doesn't anticipate having a hearing or a method in which it prescribes how these credits should be calculated, it really doesn't make a difference if the utilities will currently use the calculation method that is in place today, which is, I believe, the SOS method that was discussed earlier. If that can stay in place until the Commission makes its determination in terms of a different method of calculating and distributing those credits, I think you have an opportunity for the customers the next go around to have that information in place, and they can make a different election at that time. So I think that addresses your concern in the sense that
Okay,
the
so-
customer will have the information.
Right, so March 1st, they won't have to gain approval from you in order to make the election. So that would be the sort of a cutoff in terms of having in place something informing the customer about what the value of those credits would be if they went with an indefinite accrual as opposed to, so it's not something that we have to make a decision on now. We would have until March 1st in order to put something in place.
Precisely, yeah.
Okay.
Because the choice that is made by the customers today wouldn't actually go into effect until the next cycle, true-up cycle.
Okay. So why don't we go down the line with the rest of the companies and why don't you comment on sort of everything that's on the table, so to speak? So.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers appearing for Pepco and Delmarva Power. Appearing with me behind me is my subject matter expert, Ms. Janique Williams. We have nothing to add to staff's presentation. We very much appreciate their thoughtful analysis. We also appreciate the comments from OPC. In terms of in responding to Commissioner Suchman's question, I think I would agree with Mr. Michel. If a customer starting October 1, if they did elect to go to accrue their credits on an indefinite basis, that would not start until the end of March or the beginning of April of next year. So I think there is a little bit of time. One additional thought to consider is that in terms of the credit, what the payout would be, I don't believe that becomes an issue. As of right now, it's calculated on the prior 12 months. So if we start on October 1st, then it would not become an issue until we start going beyond the 12-month period. Because up until then, if a customer wants to switch back to the 12-month accrual, it will just stay at the prior 12 months. So it's not an issue until we start getting beyond the 12 months. That's when I think a decision is going to have to be made in terms of what is the payout going to be. I hope that answers your question, Commissioner Suchman.
Well, I think my only concern is that because you would have the ability to say yes or no. I'm just trying to sort of find that moment before the ball rests in your court for the customer to know that they have the ability to make a switch without receiving approval from the utility. And it sounds like that would be sometime in March or April.
I believe that is correct, Commissioner. Under our tariffs as they're proposed, a customer may switch from the 12-month accrual over to an indefinite accrual for any reason, no restrictions whatsoever. And then under the tariff language that the PHI companies have proposed, a customer may switch back to a 12-month accrual once every 12 months for any reason, no restrictions. So essentially what a customer may do is they may start on the 12 months. They could switch over to the indefinite accrual, and then they could switch back and then switch again. So there is some flexibility there in terms of how a customer can switch. So I think that's a key distinction to keep in mind, is that when a customer is on 12 months, they can switch over to indefinite accrual with no restrictions.
Yes, good morning, Mr. Chairman and Commissioners. My name is James Meehan, counsel for Potomac Edison. With me here today is our subject matter expert, Stephanie Fall. The company agrees with staff's presentation and has nothing further to add. We appreciate them sharing that with us here today. As it relates to the concerns of OPC, I think they've been spoken about at length, and we do have, in the interim, until such time as the form would be developed, we do plan to include language on our website to address the two different methods that are under discussion and how a customer can switch to those methods. As far as the circumstances that will approve the switches, our tariff language aligns with Senate Bill 143. We don't plan to deny any customer the ability to switch unless it's more than once in the calendar year. So that's something, to Commissioner Suchman's point, I think that's kind of where we're falling in terms of you're looking for a deadline for additional information. And then as far as the methodology, we would continue to work with the net metering working group and would comply with whatever the methodology is approved by the commission.
Okay, other questions from the commissioners?
Thank you. Oh,
Yeah, no, you go ahead.
Okay. So let me ask a very baseline question. Does the law or does regulation have any requirement for customer education on this?
Your Honor, I do not believe that that is required by the changes made in the law.
Okay, because I heard one company say that they were going to put an explanation for this on your website, I presume. That P&E, you were going to do that.
Yes, that's correct. That's what we intend to do in the interim period, is to provide additional information for customers so that they're aware of the two different methodologies, or the two different methods and how they can go about doing a switch until such time as the form that's under discussion is approved and implemented.
Well, and this is not the fault of anybody in this room right now, but I'm a little concerned that the term accrual is something that most people aren't very familiar with, and they're not going to know how to make a decision. To staff, let me just ask this: is it the intention to create this form as a mechanism for helping consumers make the right decision for themselves? Is it something that would identify what the differing financial impacts of the two elections would be? How is that the purpose of the form?
To my knowledge, the purpose of the form was to streamline the process of recording a new customer's election and whether they want to accrue indefinitely or on a 12-month basis.
So it's not going to be like the standard IRS form where they ask you to put in certain numbers and do a calculation to decide what election would make the most sense for you from a tax perspective. This is not a form designed to lead the customer through a process that would result in him or her making the proper decision. It's just a form required to allow the person to make the election, presuming they know what the correct decision is.
That's correct.
Okay, thank you, Mr. Chairman.
Commissioner Richard.
Thank you, Mr. Chair. Just to Mr. Oslander and OPC, just so I understand, looking at your recommendations, where they are in the process. At this point, do I understand that everything is being discussed right now in the net metering work group?
Yes.
So, okay, so there is discussion. Which of these items would need to be done in regulation? Is it just the credit calculation?
I think that the value of the credit is the one that is probably best handled in regulation. I think that the other elements that we raised in our comments could be done either through a combination of regulation or tariff provisions, or through tariff provisions. I think that the form that the group has been talking about, we haven't seen any draft form, so I think that there could be a difference among the parties as to what they envision the form to ultimately look like. I think from our perspective, we were hoping that that at least one of the things that would be accomplished through the form is customer education as far as the effect of their election and their ability to switch back.
Okay, but you'd anticipate, though, the work group would then get back to the commission either with a recommendation or a decision for us to make prior and in time for the March 1st time deadline, I guess if we call it a deadline.
Sure. Yeah, I do think that as the other parties here today have pointed out, the ramifications, I think, of what OPC is concerned about wouldn't really rear their head until a bit down the line after somebody maybe has elected to accrue indefinitely, banked significant amounts of credits and then seeks to cash those credits out in the future. I think that there could also be the concern, I guess, in the immediate at this immediate time is, do customers understand that they have the ability to make the election, and then how do they understand how they would go about making that election? And I think that a form approved by the commission would serve to accomplish that.
Okay, but I guess what I'm just trying to get to is, so when you say down the line, I mean, is March 1st the date that it would be optimal for the commission to provide some guidance to the work group to accomplish what you're trying to advocate today?
I would say that, yes, certainly if the commission made a ruling addressing the issues that OPC had raised, then OPC's concerns would be addressed. I mean, we might not be happy with.
Okay, I just want to understand what the timeline is. It sounds like March 1st is that date. Is that correct?
Yeah, I think that if it's done by March 1st, that's fine. Even if it was done slightly after that, I mean, this would really be an issue, I think, if customers bank credits and then they have a significant number of credits banked up, and then in that meantime, we don't know exactly how the,
Okay, I get you. I was just trying to understand if there was something we could provide specifically for you today on these issues. But it sounds like the work group is already working on it, and progress is being made. And at this point, you don't require any type of guidance as far as a date certain to have this work done.
We would certainly agree that a March 1st deadline to get to get this back to you would be a workable deadline, and one that would be able.
So that would be an optimal time.
I agree. Yes.
Okay, that's all I wanted to find out. And then finally, as with the proposed tariff changes, at this point you are satisfied with BGE, or sorry, BG and PE are the two companies that you would prefer resemble more like what DPL and Pepco are providing. Is that correct?
That's correct.
Okay, and PE just provided like some information about what would be acceptable. Is that in line with what you're getting from DPL and Pepco?
So yeah, I think that we agree with how the utilities have represented they will handle this matter. So I don't think that there actually is a difference among the parties as far as what they plan to do.
Okay.
I think that we just had an issue with the way the PE and BGE tariffs are currently worded, because it of the way it uses the language from the statute that says unless the company approves the switch.
Okay, so you're not concerned that the BGEP are really off track right now. It's just that they're not providing it today, and your recommendation is that we go ahead and accept all the tariffs, but with direction that we they firm up in a certain time their tariffs with us.
I think OPC would prefer if at some point in the future, perhaps after the valuation method is presented for commission approval and approved, that conforming tariffs be
okay. I'm talking, yes, and that's the March 1st for everything. Mm-hmm. But as far as the BGPE being like DPL and Pepco, that is something sooner than later, before March 1st, you'd like them to clear that up.
Sure, and we are. I mean, we're not necessarily saying that the PE and BG. I mean, we understand that they actually have discretion under the statute to set the circumstances, so that we're not saying that they have to do what exactly what Pepco and DPL did as far as the timelines and.
I understood. I just wanted to find out if there's a problem here that we need to be specifically addressing, or it's just simply you'd like them to have.
I mean, I think that what OPC would prefer to see from the commission today is just some, tacit approval that the work group should continue working on the form, and then what we would like to see, that maybe not all parties here at this table would agree, is that we should also move forward at this time in the net metering work group to discuss the method, a methodology for valuing those bank credits, and submit that to the commission for approval sooner rather than later.
Okay, at least by March 1st. Okay, well, I certainly tacitly agree. So, thank you, Mr. Chair.
Commissioner O'Donnell, any questions?
I have no question, Mr. Chairman, but just generally, giving direction to these work groups somehow feels a little bit like putting the cart before the horse. We shouldn't be advising them or giving them advisories. They should be advising us.
Any other questions? Commissioner Sushman?
Mr. Auslander, you had suggested that maybe we could address the calculation of the credits through Comar. Is that correct? And Mr. Delgado, you had suggested earlier that Comar amendments needed to occur, and you're going to be proposing something to the commission. And I'm sort of following up on Commissioner Barvey's sort of questioning about the form. I'm sort of wondering if the form is the right place to be putting the issues of concern for OPC, and that maybe we could address that in Comar. Does that make sense to you and maybe to OPC? And then maybe sort of following up on Commissioner O'Donnell's concerns, maybe we can, instead of directing that the work group sort of address these things, maybe we can task staff to propose to us modifications to Comar that would address the concerns that OPC has raised today. Does that make sense to you, Mr. Delgado, and maybe Mr. Oslander?
Yes, it does.
Okay.
It makes sense to OPC as well, and to Commissioner O'Donnell's point, we I think as a group would have preferred to have a little bit more time to implement the statute. We had a very short deadline and other things that the net metering work group has been working on. So I think that the parties, everyone at this table, did their best to to present the tariff changes that needed to be implemented by October 1st. And I think that the discussion today really has to do with just some unfinished business that the work group wasn't able to fully resolve and submit to the commission for approval, but that it's the intent of all the parties here to continue to work on it.
Well, perhaps in recognizing the timing of this, so that something should probably be in place around March 1st, does this give staff enough time to put together some Comar changes to address these sort of final issues?
Your Honor, the net metering working group has two rulemakings coming up in regards to making the community solar program permanent based on the requirements of HB 908. So you will be seeing in the first quarter of next year, at the latest, those rules coming before you. There is also a second set of rules that are required by the law, but they have a 6-month later implementation date. So there are two rulemakings. I think we anticipated that these changes, along with a number of other changes, some are housekeeping, some are to be compliant with the PC 44 requirements, would come in the second rulemaking, which is likely to reach you. I really can't put an estimate on it. The first one is something we have a draft set of regulations you're going to see, hopefully no later than the first quarter, or we won't meet the deadline for the legislative requirement. So we have a second rulemaking that we intend to handle the consolidated billing portion of HB 908, and I think we have talked about this amongst the work group members, and it seemed to have agreement that we would roll these Comar changes along with any others that are necessary in that second rulemaking. It's our intent to get the permanent program regulations for community solar before you in a streamlined fashion without having anything that would slow that down. Because
No, I appreciate that. The problem though is that I'm a little concerned about the timing, and so I guess I'm going back to the utilities to ask if there's a way in which you can signal to customers that there's going to be some flexibility, a little bit more flexibility, in terms of changing from a 12-month accrual to an indefinite accrual until the issue about valuing the accrued credits can be resolved. Because it sounds like we couldn't get regulations in place to coincide with the time in which customers would actually have to make the decision about which approach to take. So I'm hearing that the utilities will be flexible, but I think this is just going to give customers some comfort that until they know for sure what the value of credits would be under an indefinite accrual approach, that they have that ability to make changes once they see what the value of the credits is.
Your Honor, the indefinite accrual is definitely going to be worth more to customers, because when you are paid out for excess generation, you do not receive distribution credits, so that could be like 4 or 5 cents, or transmission credits, which is a penny or so. You just receive the commodity rate. So the change to the law, I think, is anticipated to be a means that customers will receive more value for the solar that they generate, because normally if they have anything left over when their April meter read is taken, that excess is paid off to them at a value that is less than the full retail.
As opposed to keeping the credits and then using it to offset whatever you use in the subsequent year.
Which is why there was an immediate controversy as to what the default should be, and we have worked out an arrangement whereby any new customer will have that opportunity to make that decision. It's not anticipated that a customer is going to be thinking about what their SOS rate is or what their supply rate is when they make the decision to make an indefinite accrual. It's probably likely that most customers will be perfectly happy to allow that indefinite accrual to happen, because they'll get the immediate use of energy in May that they would not normally have gotten.
Okay, and they would know this because the utility will tell them? Or you're assuming that they're a
So-
sophisticated customer that will understand?
If someone is, so it's quite possible that they won't know, and then the community solar subscriber organization will sort of advise them of this, or then maybe default them into this, because it's clearly more advantageous for them to retain those credits so they can use them in the months following April. So they may not even know. The concern was, well, there are customers that maybe are happy to get a little check, and it should be a little check. It should not be, we are not trying to create any sort of situation where customers would deliberately overbuild and then be selling power back to the utility for excess generation. In fact, part of the issues that we need to deal with is to make sure we do not create some sort of unintended consequence as an incentive, because we will have to make, if we have to sort of protect against that, it makes things more complicated.
Okay, and Mr. Oslander, is that some of what you would like to see, is having that kind of information in the hands of the net metering customers so that they can make informed decisions at different stages of their participation in the program?
Absolutely. And to your point, Commissioner Sutherland, I do think that a lot of what we do in this room sometimes does not always it's not always communicated clearly to customers. I know that our office does make an effort to put out fact sheets, and we do various outreach, but certainly taking the steps that have been talked about today will be better than not approving a form, for example, and not and requiring essentially customers to figure this out on their own. And at this point, I think that would be especially difficult because we sitting at this table haven't entirely figured out exactly how this is going to work. So I think that we need to do that first, and then I think we need to communicate what what the commission ultimately decides to customers.
Okay, thank you.
So, question for...
Hoover, it looks like Commissioner.
Oh, okay, Commissioner O'Donnell, why don't you go ahead? So,
Yeah, just to say that to Commissioner Suchman's point, it's not the end all be all, but maybe an addition to our website at the appropriate place would be accrued to the helpful side of the ledger here, so in educating people.
okay.
Thank you.
So, question for BG&E and PE. This issue about the language that says approved by the company. I guess there's some charm in having all the tariffs look alike. So I guess the question for you two is, how wedded are you to that language being in your tariff as opposed to not being in PEPCO and DPL's tariff? And
Joel Michelle on behalf of BG, we have no objections to OPC's recommendation that we revise the proposed tariff language to be in uniformity with the other utilities.
And PE?
PE will certainly work with the other utilities so that the language is similar to in as much as possible.
Okay. All right. So, let me make a motion that we accept the tariff revisions for filing as revised by staff in its comments on each of the utilities dated September 20, 2023, along with this additional tariff change regarding the language as approved by the company, with an effective date of October 1, 2023, that we direct the companies to file clean copies of their respective tariffs, and that we grant waivers of COMAR 20.50.10.05 E1 and 20.50.10.07B until the regulations are the updated regulations are published. And then the final aspect would be an instruction to staff to start the process of working on both this form that'll get approved by us at a later point, and any changes in the regulations to fully implement the new statute. And with that, we'll start with Commissioner Sushman.
Aye.
Commissioner Barbe. Aye. Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.